The Honorable Caroline Kendagor is the Mediation Deputy Registrar in the Judiciary. She joins us now in the studio to have a conversation here. Good morning, Honorable Kendagor.
Good morning, and thank you very much, Eric. I'm happy to join in the show.
Karibu sana. Now, Mediation Deputy Registrar. Let's just start from there. What is that?
Thank you very much. I serve as a Mediation Deputy Registrar. I am employed in the Kenya Judiciary as a magistrate, but I perform administrative support. In this instance, I serve at the secretariat known as the Court Annexed Mediation Secretariat, which is a national secretariat that oversees the implementation of the use of court annexed mediation as an alternative dispute resolution mechanism. And the secretariat coordinates the courts that are where we have rolled out and are implementing mediation.
What is court annexed mediation?
Court annexed mediation is an alternative dispute resolution mechanism. In this instance, anchored in court or under the umbrella of the court. And mediation is an alternative dispute resolution mechanism where parties in dispute are assisted by a neutral third party to reach a negotiated settlement, different from the adversarial resolution where the disputes are heard and resolved by judges or magistrates.
How do you decide what goes towards court annexed mediation?
We have a screening criteria where we look at the cases that have already been filed. The current model that we have enables parties whose cases have already been filed in court to benefit from the process. And we look at a number of issues for those cases where we give a classification that pleadings have closed, which is generally really that all the documentation that needed to be filed by all the parties in dispute are already in place. And most of the cases that we have in our courts are eligible to benefit from court annexed mediation. The only criteria that we sieve through are three cases that we do not refer to mediation. One is cases where we call them the public interest litigation cases. Those ones may not be suitable for referral to mediation unless there's a discretion by a judge or a judicial officer in a conversation that involves all the parties. We also do not refer cases to mediation where there are issues to do with allegations of domestic violence, child abuse, sexual violence, or any cases where we feel like there's an imbalance of power that would generally interfere with the negotiation of the parties in mediation. We do not send such kind of cases to mediation. Cases where there are perpetration of criminal intentions. And then third is we also do not send cases to court annexed mediation where the parties have expressly given an intention that they would like to explore a different alternative dispute resolution mechanism, for example, arbitration.
Okay. So there's a difference between arbitration and court annexed mediation.
Yeah.
Yes, there's a difference between arbitration and court annexed mediation. And if you'll allow me to just add in again that the difference that would come in with the adversarial dispute resolution in the court process. In mediation with and arbitration and again in the adversarial resolution in court, all of them, the third parties are neutral and impartial. The difference is that in mediation, the role of the impartial third party is to assist the parties to reach a negotiated settlement. So the mediator does not act as a judge, does not impose the outcomes on the parties, but rather just facilitates the parties to be able to come into a discussion and come up with a negotiated settlement.
Okay.
In arbitration and the court process, the arbitrator and the judicial officer actually determine the outcome and control the process as compared to what happens in mediation. And in the difference, of course, between arbitration and the court process is that in arbitration, the third party is an arbitrator, and in court we have the judges, magistrates, and the cadis.
What happens in mediation if you do not reach this negotiated settlement, that you've gone into mediation, you've been there for however long a period of time, and still folks are not able to agree? What happens then?
We try to really have conversation with our litigants prior to even referring the cases to mediation to just see that they understand the process and appreciate the benefits that would come with it. And of course, we are very happy to receive cases that are settled successfully so that we don't have to have them again go through the hearing and determination process by the judges and magistrates. But even then, as we give this avenue, which is we are extending to our parties, we do not necessarily tell them that they must go and agree.
Okay.
The replication model we have assumes a mandatory nature only in the terms that once your case is screened and found suitable for referral to mediation, then you are required to submit to the process to abide by the rules of engagement and the statement of understanding that the parties and the mediator will arrive at, but we do not tell them that they must go and agree. So where they fail to reach settlement, we have these cases back in court. We give directions that facilitate their hearing and determination. And out of experience from the cases that we already have, is that even when parties do not reach a settlement in the mediation process, as at the time they are coming in for the hearing and determination before the judicial officers, it is seamless, it is less protracted, and the cases move faster, and parties sort of have a common approach in terms with how they relate with each other during the dispute resolution.
How do you enforce the outcomes of both mediation and arbitration?
For arbitration, the arbitra's award is forwarded to court, and it is adopted and enforced. Similar for the agreements that are arrived at in under court annexed mediation, they are adopted before the judge or the judicial officer who referred the matter to mediation, and they carry the same weight that they would carry with regard to a decision that would have been made by either a judge or a magistrate. And we proceed to issue the orders and decrees in the same manner, just like the other cases that have been determined, and they are enforceable in a similar manner.
Can they be appealed as well?
Under court annexed mediation, the right to appeal is taken away just purely to be able to avoid the issue of litigation by installments and the delay that would come with it. And of course, we'd really like to ride on the fact that this is a decision where the parties arrived at in a negotiated process. They had the opportunity to participate with any personal representatives of choice. And the reason why that is open is to be able to ensure that sometimes some of the cases that come before us do not necessarily fall within or are not between the disputants in court, and may be stretched out to either people whom the parties are litigating under, or families in succession and family disputes. So to avoid that back and forth process, the mediation process gives the parties an advantage that litigation comes to an end once they sign and execute the settlement agreement.
Honorable Kendago, just give us an example of a case that goes before a judicial officer, and then the judicial officer then sends it to the court annexed mediation. Just a case study.
Thank you. This would be a case which would either be have been filed at the registry and either does not have a date before a judicial officer. In that instance, we look at the pleadings they've closed, and we screen it in a pretrial process where we look to examine whether it falls within the criteria that I had talked about earlier. The second bit in which this matter can again come to mediation is for those cases that are already before the judicial officers and the judges, and in a judicial discretion, they have looked at the file even when pleadings have not closed, and they find that the cases can benefit from mediation. The other third process would be where parties themselves request to be referred to court annexed mediation. We prepare notices notifying parties that their cases have been found suitable and have been referred to mediation. We appoint a mediator from a register that is kept by the Mediation Accreditation Committee, and we communicate to that mediator that they have been appointed to act as mediator. Thereafter, the mediator will contact the parties and advocates in the matter. They will come for a session, which can be either physical or virtual. They will set up their own rules of engagement, which would just facilitate a coordinated process. And then thereafter, they would notify us of the progress in mediation. And we're happy to receive the outcomes, which would either be that they settled or failed to reach settlement.
Without giving specifics of a case, can you take us through one case that has successfully gone through this process, and then you'll tell us the benefits of it?
Thank you. We've had lots of success stories out of mediation, both in the family and I'd like to give a classification of the other disputes which would fall under the civil category. We have an example of a dispute that was pending in court for 30 years, a succession cause that was very protracted. And as at the time we were referring the matter to mediation, the parties who had applied or petitioned to be administrators were deceased. We were actually at a third generation as at the time the matter was being referred to mediation. And parties were able to reach a settlement by agreeing on the administrators for the estate. And they further went on to even agree on a schedule of distribution, which had taken a very long time and had really strained the relations of the family. Another example is a commercial dispute that had been pending in court for over 15 years, which was resolved in 15 days in mediation, and released money that had been locked up in litigation, where, as at the time, in fact, parties were almost at the age of just giving up with monies that had been deposited. They cannot access them, neither of them, and the dispute was on and on. And out of the settlement agreement that they reached at, they not only accessed the money, but again, they restored the contractual relation that existed between them.
In the case of the succession, a 30-year-long dispute,
Yes.
what was it in the court process that was keeping this matter in court for so long? And what was it that mediation helped to avoid or to resolve?
Mediation looks at more in terms of interests as opposed to the law. So when you take a hard line of the law, you might not necessarily be able to resolve the dispute. And then again, what parties indicate in pleadings is not necessarily the situation back at home, or sometimes even what is required in the resolution of the disputes is not something that can be issued by the law. And in this particular instance, the party that had taken a hard line were actually feeling like they were being taken advantage of, and sometimes just an apology or just a recognition and an embrace as between family relations, and telling them that we recognize your position, you being a part of this family, and recognizing your interests, for us to be able to come to the table and now just discuss as to how we can enforce what is already there.
At whose behest is it? Or can the parties request for this kind of mediation? Or is it at the behest of the judicial officer to now say, let's actually remove this from the court process and let's put it in mediation? Who makes the decision? Who can make a request?
Both. We can have the court make a direct issue directions that the matter is referred to court annexed mediation, and we can also have parties requesting. The advantage of having the parties themselves request to go to mediation is that they are more amenable. You don't struggle with the explanation of the roles and responsibilities by virtue of you are getting litigants who already appreciate the benefits that would come with it, and they take a shorter time, and the outcome of their mediation is likely to settle all the issues in disputes.
Is the judicial officer mandated to offer that solution or suggestion to the parties before that?
We are bound by Article 159 of the Constitution, which requires that the judiciary promotes the use of alternative dispute resolution mechanism. So, of course, it is one of the major questions that comes in even with our litigants when we are telling them that we are referring them to mediation, because when they file the cases, they tell you that I filed my case so it can be heard and determined by a judge or a magistrate. So we have to sort of like share the journey and what is our role in this context of promoting by ensuring that this avenue is actually available to you, walking you through the rights and the responsibilities that would come with it, and generally controlling the process to ensure that the parties benefit in a similar manner that they would benefit if the cases were in court. And then, of course, again, beyond that is that We have also institutionalized the implementation of the use of ADR mechanisms. So currently in our performance measurement management, which we set targets every year, we have included a measurement on how, as judicial officers, we are promoting the use of alternative dispute resolution mechanisms.
Something that I've often wondered about, when people take matters to court, is it that they believe, that is of course in your experience, is it that they believe that this is where the matters will be resolved, or is that just the only option they think is available? Or is it that they don't actually, this alternate mechanisms for this dispute resolution, they don't actually fully understand it?
Yeah. The alternative dispute resolution mechanisms have actually been with us, and one of the biggest questions is really what is the alternative? Is it the court that is the alternative, or is it these other dispute resolution mechanisms that are the alternative? And I would say quite a bit to do with a need for a culture change, for us to be able to appreciate that our disputes can actually be resolved through other mechanisms without necessarily having them being filed in court. If you'd allow me to just mention that currently there's a task force that's working towards an ADR policy that will give a formal recognition of the ADR mechanisms that we have in the country, which will now just help us to be able to not only give platforms that we can now sensitize and have people coming in on board to appreciate these ADR mechanisms, but will also provide frameworks under which we can sort of like benefit on these ADR mechanisms besides cases being filed in court, and to give us an opportunity that we can move away from the threat that anytime there's a dispute, we tell each other to kutane kotini.
Let me ask the question again, because you see there's a lot of information that is available to those who seek it. But if I'm thinking of our population, the majority of whom are actually in the rural areas, and who, like the rest of us, have issues that they require resolutions for, how, to what degree has our judicial system cascaded these processes to some of these parts of our population where I think, in my mind, that mechanism perhaps would be received or accommodated easier if it was presented in a way that they feel would actually meet the needs or the requirements that they have. How far have we gone in cascading these services to our rural folk?
Thank you very much. With Quota Next Mediation, we are currently at 17 counties, and we are hoping to hit a target of 25, and with a 3-year plan that we are hoping that by 2024 we'll have implemented in all our courts. The main issue why we embarked on our first implementation was really to do with the financial implications that come with it. Under the process, the mediators are paid by the court and not the parties. And then there are also other infrastructural issues that would come in with the special nature of the kind of suits and rooms that are required for mediation, which are different from the conventional courts that we have. And then, of course, there's also quite a bit, as I mentioned, about culture change and the need for sensitization, which the judiciary has really taken up to just see that we are doing sensitization both in advance of the rollouts, but again, even when we do the rollouts, to be able to reach out to I would say all the village and people who perhaps may not have filed the cases but would need to know that as at the time they have disputes, they have these avenues. Is during the rollouts, we try to leverage on already existing institutions. So we leverage quite a bit on the national and county governments. We try to have a forum with the chiefs so they can just understand what the process is about. We do a lot of sensitization with both professional and community-based institutions for them to know who are these alternative dispute resolution people, who are the mediators, who are the elders, what are their roles, who is eligible to apply to become an accredited mediator, so that they not only appreciate what the process is about, but again, they also know that they are not, it's not an area that is necessarily just locked up for lawyers or the legal profession. But it's not something that I can say the judiciary by ourselves only alone can absolutely take up the issue of
Let me ask,
sensitization.
what are the qualifications? What do you need in terms of qualifications to be you
A
call it-
mediator.
No, registered. He is not just mediator.
A registered mediator.
Yeah, you can just be mediating kienyeji, but now registered. Where the court recognizes you as a mediator.
Yeah.
Yes.
Well, there are very good mediators out there who perhaps may not have gone through formal training as mediators, but they have the knowledge and the skills. But because this is a court process and under the umbrella of the court, we needed to have some form of regulation that would give the assurance of our clients that they are coming to a process that is regulated, that we have sifted through the mediators that we have on board, that they have the same capacity, the same code of conduct like the way they would have with the judges and the magistrates handling their cases. So because of that, we have an accreditation committee that is set up under the office of the Chief Justice, that we have applications that are made by eligible candidates, and they go through an accreditation process where the examination is to look at that they have trained as mediators. They should be having some sort of like background with a professional institution or affiliation that we can fall back to in the event that we need to enforce the code of any implications that come out of breach of the code of conduct. We not necessarily require that they must come from a legal field, but it's desirable that they have a first degree. And the examination on that they have already conducted mediations. And if they haven't, then we place them on a mentorship program, which they can subsequently apply to be given an active status once they have satisfied that they have experience.
Hey,
Wow.
it's
Wow,
a-
wow.
It's like med school.
It cannot just
so
be
we
a
have
you know,
really good
hii mambo
mediators.
tukatatue kinyumbani.
No.
No.
This one, from what?
We continue. Eric Latif Nduo Kositi Muga, our guest this morning. Hashtag Justice Thursday is the Honorable Caroline Kendago, Mediation Deputy Registrar in the Judiciary. We are talking about alternative dispute resolution mechanisms and specifically court-annexed mediation. Dominic had asked a question, must one be a lawyer to be a mediator, and what do I need to do to know to be a mediator? And you just took us through that before we took the break. Requirements, among them first degree, and then you take them through some training and then there's some vetting, basically just to make sure that they understand the process and the importance of the job that they're taking. And then they are accredited, and there's a department that does the accreditation under the Office of the Chief Justice. There are very many questions that will come after that. City has one.
I do. Because if I look at the court system we have in the country, it is tiered. You go from one level to the next and to the next, and for very good reasons. Now, if you are going to have a mediation process, this is really what I was asking. Should it also not be tiered? Because if you're talking about resolutions that emanate from, say, the simplest foundations of a community setup, does it require the same rigor as you would if you, say, took a case to the Supreme Court? The answer is no.
Yes,
Yes.
the answer is no.
Yes, there are things that can be resolved.
Yes, the answer is no.
Yes.
Yes, the answer is no. See, I'm speaking English.
Yes. No.
So what I was asking was this. Most problems that end up in court, in my view, end up in court because a resolution was not found at a level where these people who are in conflict could actually find or could perhaps seek one. So, and you had begun by telling us how it is that there is a process that is in play to ensure that at these levels, such matters can actually be resolved. So,
Thank you very much, Siti. So what happens is, just to borrow through from the issue about the accreditation, is that we are coming from the instance where these are cases that have already been filed in court.
yes.
Then, so to be able to give that reassurance is the one now that we have the accreditation and more of like an examination on the kind of mediators that we are having on board to be able to have the clients benefit of a similar process like they would if they were appearing before a judge or a magistrate. The other platform that would be there around the use of alternative dispute resolution mechanisms are those ones that are held at grassroots level. where parties discuss the issues in dispute and they may reach a settlement. And currently, with the legal framework that we have, we do not have an opportunity where they can come and file those settlement agreements directly in court without necessarily having to file cases in court seeking their recognition and enforcement. We are working on mediation rules that will give an opportunity to the parties to be able to enter into settlement agreements outside court annexed, which is cases which have not been filed in court, and which does not necessarily mean that these mediators must be the mediators that we already have under the court annexed mediation program.
Yeah.
But there would have to be quite a lot to do with capacity building around that practice area of mediators to ensure that the kind of settlement agreements that are coming in will be valid agreements that can be recognized and enforced in law. And when that happens, then we'd be able now to be an added advantage to the use of mediation compared to where they have to file their cases in court and then seek to benefit from court annexed, and now giving them an opportunity that they can reach a negotiated settlement outside without having to file cases in court. But they can bring those agreements to us in court. They are recognized, they are adopted, and they are enforced like the way a judgment or an order would be.
You know, there's a whole system in our communities, right?
Yes.
Like you're saying, actually the judiciary is in many cases referred to as the alternative dispute resolution mechanism.
Yes.
We had all this. We have the injury in checker, we have the loy bond, we have all of these elders. Do you recognize what is decided by the elders? For example, if there was a dispute and it's taken to the injury checker and the wazir of the injury checker decide this is what is going to happen, and the matter then comes before you, would you consider that like it's an appellate stage of what was already being resolved down there?
It would really not be an appellate stage, but we have cases that are already in court that we divert into the alternative justice system. So we refer to already existing mechanisms that are available either at the village elder or at the chiefs, or just setups within the communities, and we ask them to sit, discuss with the parties. And they come up in most cases with a settlement, which is may not necessarily be acceptable to the parties, but it is something that a decision that was arrived at by the elders. And then we have those instances where there are those settlement agreements I would say outcomes that are arrived at in such situations that may not necessarily be cases that have been filed in court. So in those instances, in both of these instances where there are cases that are in court and in instances where the alternative justice system is done but the cases are not in court, they are bound by they are bound by our constitution. So they must be within the articles of our constitution on human rights, and they cannot derogate in any way from that. Where these outcomes are being brought to court, we do sort of like give them a recognition, but they are not necessarily binding on the court. So the court can consider what the outcome and the deliberations that happened in those forums, but they're not necessarily binding in court, which would be different from now the setup that we have under court annexed mediation, because when the parties reach a settlement, we adopt and it is binding.
Okay. You talked about, going into the rural area, and then because of funding that would happen, maybe at a later stage, rolling that out. And then with AJR, we had Justice Ngugi here who told us about working with the community on certain levels. Now, as we look at court annexed mediation, also trying to go into the rural areas and probably dealing with a lot of cases that may not necessarily have the required judicial documentation. Do you see any blurred lines between the two, court annexed mediation and AJR, or are they complementary to one another?
I would say they are complementary to one another. Both of them are initiatives by the judiciary with the same objectives that would have our clients have a different experience with the court process. And in all instances, we are giving the control of the resolution of these disputes to the parties. So they complement each other. We work a lot together in terms of sensitization so that we ensure that even as we talk about alternative dispute resolution, our parties or our clients would understand what are these mechanisms that are all available to them for use.
There's something that, as you were speaking, my mind went to. I was thinking about other institutions within government, and I was thinking of the education sector and how it is the training and teaching is tiered. Early childhood education, primaries, and the qualifications that were required at every stage was intended to meet the needs of that particular stage of a child's growth. Okay? Then I looked at the health sector, and I looked at how the health sector has grappled with alternate ways of dealing with health problems in communities, and specifically thinking of traditional birth attendants, okay, what they called TBAs, and how it took time for the health sector to actually integrate these people into the system. And I'm saying integrate because the communities already accepted these people as healthcare providers.
Yes.
They did not need the Ministry of Health to tell them. They already accepted. And there are many people who are born through this very same system. Now, integrating them into the so-called formalized system simply meant that you are enhancing the experience of those who needed these services.
Yes.
It is with that thought in mind, again, that I'm actually going back to this because the need to train people without a shadow of a doubt is necessary. It's absolutely. The need for accreditation of some sort also necessary so that people feel that there's a safety in the way people are going about it. And they also understand basic guidelines. So one community to another, you're talking about the same thing.
Yes.
My problem is this. When you say in 3 years we will have reached the grassroots, what exactly will we have reached the grassroots with?
Thank you very much. We will have facilitated them by setting up mediation registries across our court stations, which means that would move away from the 17, as I mentioned already, which does not necessarily mean that the other courts that do not fall within the 17 cannot implement. But we are moving on a phased aspect, and the classification really is we're just giving priority to the courts that have huge case backlog. We are giving priority to courts that have a long case turnaround time, and we are giving priority to our courts who have a low customer satisfaction survey. And then again, there's the bit I think you mentioned about the education and just generally where we are coming from is we come from, I think, a background as a country where the only dispute resolution mechanism that is taught even right through in our structured training in schools and right through even to the trainings in colleges, the advocates, we are given a background that dispute resolution can only be through litigation. So, to be able to cap that as an institution, we are working very closely with the training institutions that are there, the schools of law, to be able to start right through with a culture change at that instance with the lawyers that are coming into the field so that we can not only help our clients to appreciate, but again, we can also as ourselves participate well in terms of our responsibilities and roles in mediation.
Do you face challenges when, as a judicial officer, you are proposing to the parties, there's an available mechanism that you can use outside this court?
Yeah.
Do you face challenges, and sometimes you see those challenges actually coming from the lawyers who should know better, but they are saying, hey guys, no, this is the best way to go?
Yeah, well, for a very long time, one of the issues that we struggled to have our colleagues in the legal profession to understand and work with us along is that ADR does not necessarily mean that their returns are diminishing in any way. I remember at some instance when we would talk about ADR as alternative dispute resolution mechanisms, one of our colleagues in the legal profession said it is accelerating diminishing returns. But we'd like to look at it more like this is an instance that we're giving you an avenue to be able to resolve your dispute faster. Your clients live there happy. It is less protracted, which means that even the kind of energy that you spend there, yours is just purely to facilitate your clients by supporting them to understand the process, to guide them in the kind of settlements that they enter into, and then we also have them participating during the mediation sessions. We have come a long way in terms of the sensitization and even come up with structured engagements where we can have the lawyers on board through engagements in their continuous professional development forums. We work very closely with the Young Lawyers Committee of the branches that we have, and then we have also set up bar and bench committees where we involve the mediators, that we can have feedback from the three groups of the lawyers, the judiciary, and the mediators that we have on board. To be able to take care of the kind of resistance that perhaps may come, we do case management for the cases that have been referred to mediation. So at every particular instance, there's a relation as between the deputy registrar who is in charge of the mediation files and the lawyers to just pick up, is there an issue that is going on that would require intervention? Is there anything that we can do to improve the process? Is there any feedback, for example, from the clients that perhaps they haven't communicated to us? And again, similarly, we get that kind of update again coming in from the mediators. Currently, 60% of the mediators that have applied are from the legal profession, very different from when we started, where majority of the mediators that we have were from social backgrounds.
There's something that I want to ask. You may not be the right person to ask it, but I'm going to ask it nonetheless.
Yes.
The police service are an integral part of the judicial system.
Yes.
Now, just like there's this training that you have for would-be mediators, do you think that the police service could also act as mediators? And do you think that they could also be trained? Because they deal with issues that require, in my mind, mediation on a daily basis.
Well, there are partners in the justice system, and a lot of what they do has a lot of effect in terms of just the experience of litigants in justice. So usually when litigants talk about the experience, they will say, I had a very bad experience with a case, and you'd basically think that that experience is right through from the court, but it starts right through from the time of your first engagement with any particular person in this roller coaster of the justice system. So yes, it's important that they also have that form of training on how to use the alternative dispute resolution mechanisms to be able to know which ones should not go, so that we don't have instances where cases under the Sexual Offences Act, for example, are referred to ADR. But we also have other ADR mechanisms that we work very closely with the Director of Public Prosecution that would benefit more criminal cases. And there's quite an engagement under the National Council on Administration of Justice to just see that other partners in the justice system, including the police, are trained on what are the kind of ADR mechanisms that are there and how to go about it towards the facilitating parties to benefit from them. And we have a number of police people serving in the police who are trained mediators.
Oh,
Okay. You mentioned 3 instances where cases would not qualify for mediation, court annex mediation. You said when parties have chosen to go for arbitration, that's clear. When you have domestic gender-based violence, cases involving children, Sexual Offences Act, don't take them to mediation. That is clear. Then you also talked about public interest litigation. What's that?
Public interest litigation are cases that would require a formal determination by the court, which means that the interest that is in dispute here stretches through beyond the individual person of the parties that have presented it. Just to give an example is, for example, Eric, you and I cannot file a case in court today and decide to sign a settlement agreement that says that we are dividing Nairobi County into 2. We cannot have, for example, mediated agreements that would set up for example, interfere with the date that we have on that is coming for our elections. So I'm just giving examples to just give a boring of what are these public interest litigation, which would span very many areas that cut through the services and the institutions that we have.
Is corruption not a public interest matter?
Corruption is not
Public funds have been
Yes,
stolen.
yes.
Okay, that's the allegation. And the person who's being taken through this process is being accused of having stolen or misappropriated or misused or misallocated or mismanaged public funds. And yet we see mediation in these cases.
Those are public interest litigation cases. There is another process that parties who have already been are going through a similar process in the anti-corruption courts or maybe before the anti-corruption agency, but I would not really call it mediation. It is some form of an ADR mechanism where you discuss on the return of the monies in this particular instance.
Plea bargaining.
Yes,
Okay.
yeah. So it's more like I would affiliate it more to a plea bargain. Which is different from mediation. So under court annexed mediation, our cases, we cannot have instances where they can come to court and say, we have agreed that it's no longer...
Tutaongea kinyumbani.
Tutaongea kinyumbani. No, that is public interest litigation that requires formal determination, and where they have to go through some other dispute resolution mechanism, they are already structured under our acts, our legislations, which would involve the agencies that we have under the Constitution to undertake those discussions.
Last one, is it encouraged from where you sit to have more cases pass through court annex mediation?
Highly encouraged, so we can not only improve the experience that we are having with the cases that we have in court, but again to be able to give parties an opportunity that they can actually control the kind of decisions that come out of the disputes that they have, so that they can have a win-win situation, which is not something that is possible for cases that are resolved by judges and magistrates or the qadis. It is also highly encouraged just to be able to save not only on time, but also on money. And then again, so that we can do away with this issue of backlog, because the generation of backlog comes in right from cases that are coming in to the ones that are already there. So if we can embrace the use of alternative dispute resolution, we can then take advantage of these legal frameworks that are upcoming, that we can reach ADR settlements and just bring them to court for adoption and recognition and enforcement in case there's a dispute. And then now we would save the kind of judicial time that we have to be able to resolve the cases that are already there and the ones that actually require formal determination.
So speak to Kenyans as people are listening to this and they're thinking, okay, there's all we've been talking about, having cases resolved through mediation. What would you tell them? I mean, the message that you'd like to tell Kenyans when they're listening to this and they're thinking, tukutane kotini is the number one thing. Wewe, tukutane mbele.
I'd like them to be our ambassadors. I would like us to have a culture change shift from tukutane kotini to tukutane mediation. I'd like them to call upon any of our court stations to be able to ask about court annexed mediation. Feel free to contact us. We'd be happy to share our contact and answer any queries that they have. We'd like them to not only talk about mediation for those disputes that are already in court, but look at it from an angle that it is an ADR mechanism that they can benefit for even cases that have not necessarily been filed in court. We are happy to have more mediators coming in on board, and we are happy to continuously having Kenyans carrying up the sensitization to ensure that everyone gets to know that it is not only through litigation that disputes can be settled.
Mnalipa ngapi mtu akiwa mediator?
We have a token that we pay the mediators that handle our matters. It's really more of a honorarium because we pay 20,000 shillings per file, which is a very small compared to the amount of money that is out there for commercial mediation. We do not ask our clients to pay these fees for the mediators because they have already filed their cases in court, and we are working towards a sustainable model that would not only just facilitate but also give an avenue of those instances where you can actually come to court and decide that without filing my case at this instance, I want to be directly sent to mediation.
Honorable Caroline Kendagor, Mediation Deputy Registrar, thank you very much for joining us today, and asante sana for coming in Justice Thursdays.
This is the Situation Room, the only way to start your day.